Hello, and welcome to a special office hours edition of Strict Scrutiny, your podcast about the Supreme Court and the legal culture that surrounds it. But today, we are coming to you in a different format in this special video, rather than just in a podcast in your ear holes, but we're still your hosts. I'm Kate Shaw.
And I'm Leah Litman. And today we are going to be answering questions that you submitted office hour style. So June has been a huge month so far because there is a lot going on, from the recent Supreme Court decisions to the Trump indictment to that Wall Street Journal op-ed to the salmon fishing trip in Alaska. And of course, we're all awaiting news of what else the Supreme Court has in store for us. So we're here to help make some sense of it all to the extent we can.
And even though this is styled as office hours rather than like a happy hour, it has been a long week on the Supreme Court beat. And Leah, I honestly kind of thought about pouring myself a glass of wine and doing like a little tipsy opining about the Supreme Court. I did not do that. Instead, I just brought a LaCroix. But
maybe next
this is
time.
the first of these. I don't know. I think we should be open to the possibility of slightly modifying for future
drunk
office hours.
Term recap.
I mean, it could be really good. It could be terrible, but I think it's worth trying. Our wonderful associate producer, Ashley Mizuo, is going to help us read the questions that we receive from all of you, including some fun ones about who we think will win RuPaul's Drag Race All-Stars. I personally will likely not be answering those. I mean, to be clear, if I did watch TV, I would 100% watch Drag Race. I just really don't watch television, so I'm useless on these questions. Leah has got you covered, though.
I definitely know that one. Okay, so we wanted to answer all of the questions you all submitted, but the video can only be so long, so please don't feel bad if we don't get to your question, especially since we are still waiting for Supreme Court decisions this summer about important things like student debt relief, LGBTQ rights, and affirmative action, so there may be another one of these office hour videos in the future.
Also, be on the lookout for emergency episodes as those decisions drop. And if you want to just kind of get up to speed on the big cases, you can always go back and listen to the discussions that we have had in previous episodes. We tend to preview the cases and do like real dissections of the oral arguments around the cases. So that's a good way to get up to speed. Or you can just jump right in to the end of the story and hear what we have to say about the opinions when they come out.
Okay, so let's start off with your questions about the decisions the court has made thus far and the big ones we are still waiting on before they wrap up by the end of June.
Several days ago, the court upheld the Indian Child Welfare Act, which is about keeping Native American adoptees with their tribes. That case was called Brackeen v. Haaland. An Instagram user asks, Brackeen v. Haaland was a custody case. What happens to the children at the center of it all?
So what I just said about going back and listening to old episodes really applies with full force here. If you're interested in learning more about Brackeen, we had the great Rebecca Nagel, who is the host of Crooked's This Land podcast, join us to break down the opinion in the case. She had previously actually joined us to preview the case, and season 2 of her podcast, This Land, is like an incredible deep dive on the litigation backstory, some of the key players, the law firms, the kind of overall arc of this case. So for sure, listen to that if you haven't. As to the specific questions, Rebecca talked a little bit about this when she joined us to break down the opinion in Brackeen. But basically, all the kids in the case itself have already been adopted. So some of the would-be adoptive families in the case indicated that they wanted to foster and maybe adopt Native kids in the future. But, you know, they were saying that it was important to say that so they could continue to have a concrete stake in the case from their perspective. They wanted the court to decide this case. They wanted the court to strike down the statute. But none of the specific kids in the case will have their status impacted by the decision, and actually wouldn't have, I don't think, no matter what the court decided, which is one of, I think, the many reasons this case probably should never have been decided, because it didn't have the kind of concrete adversity that the federal courts typically require. And the court actually agreed with that point as to some, but not all of the arguments in the case. But no impact on the particular kids at issue in Haaland versus Brackeen, but there are other cases percolating. So it's a little hard to say how any future rulings in those cases might affect potentially those kids and families.
So I just wanted to underscore one thing about how all of the custody cases were resolved, and that's that all but one of the children who were actually part of this case actually ended up with, you know, the families challenging the law, having custody, you know, over them. That is, the families who argued that ICWA actually harmed them because it made it difficult for them to adopt these children actually ended up adopting the children in all but one case. Also kind of underscoring like why they never really had standing to challenge the law in the first place.
So Charlotte asked this. I would love a deep dive legal analysis of the antitrust concerns with Ticketmaster/Live Nation that were exacerbated by the crazy demand of the Eras Tour. Did any new legal theories emerge, or was it just a case of demand far exceeding supply? Are there any cases on the horizon that could make their way up to SCOTUS? Can Swifties really bring about the breakup of a monopoly?
Okay, so I think that the Ticketmaster situation is kind of emblematic of an alternative theory of antitrust that has become popular over the last decade, in part through the writings of Lena Khan, a professor at Columbia Law School, who is now the, commissioner chair of the Federal Trade Commission. Okay, so the basic lay of the land is, Ticketmaster controls like a huge percentage of the market for ticketing, but that itself is not necessarily an issue under antitrust law because currently the antitrust regime, and antitrust professor, correct me if I'm wrong, has adopted this standard known as the consumer welfare standard that was first kind of pioneered by Robert Bork, who was, in the Reagan administration. And under that standard, as long as the kind of business arrangement ultimately, inures to the welfare of consumers, then antitrust law, is kind of fine with it. So Ticketmaster, what they did is they basically came up with these agreements where they made arrangements with venues where venues agreed to exclusively use Ticketmaster to sell their tickets, and then Ticketmaster shared some of the ticket splitting fees with them. And then Ticketmaster later merged with Live Nation, and Live Nation actually owns a bunch of venues. And as part of that agreement, right, Live Nation was obviously going to let Ticketmaster sell the tickets to its venues. And that is an example of what's called vertical integration, because Ticketmaster and Live Nation are not actually competing against each other because they're not offering the same service. Instead, they are basically occupying different parts of the market that might be related but are not actually in direct competition with one another, because Live Nation isn't selling tickets, they are a venue place. And so because, right, they weren't directly in competition with one another, that only got kind of minimal scrutiny under antitrust law. But that's where Lena Khan comes in her writings in a kind of foundational article known as Amazon's Antitrust Paradox. She basically argued that antitrust law should, be concerned with those cases of vertical integration, where a company basically controls all aspects of a process, and therefore doesn't have to rely on entities outside of the company, at any part in the process. So that's kind of how the Ticketmaster fiasco implicates an alternative theory of antitrust that isn't necessarily unique to the Ticketmaster disaster, but this case could kind of raise it.
And I mean, just and Leah, who never taught antitrust law but did a better job explaining than I would have, is right. I mean, it's even though kind of current antitrust law is way less skeptical of vertical than horizontal mergers, right? If you have two direct competitors, antitrust law is pretty skeptical, particularly if you have only two. But even if you have big, powerful players merging, that suggests there's going to be just fewer choices for consumers, and they're going to have too much market power and thus could raise prices and, actually undercut competition and things like that. Vertical mergers used to raise some concerns. The Supreme Court scaled back the scrutiny on vertical mergers. And I think it's right that you see in just how damaging to consumers any kind of excessive accumulation of power, even if it's not just between two competitors, but players at different places, like in a stream of commerce or in a marketplace, you sort of see how much danger that can pose. And so I don't know. So we should say the Ticketmaster Live Nation merger was in the early Obama administration and has been roundly criticized. A lot of people think regulators in the Obama administration should never have allowed that merger to go through, sort of even under then governing standards. But I think it is right that Lena Khan at the FTC has suggested that, with respect to Amazon, but also I think noise is made about lots of other kinds of players, that there should be a much more skeptical look at, mergers and kind of market dominance broadly than there have been in the sort of, consumer welfarist age that I think Leah's right, Bork is sort of most closely associated with. And I'll just say one thing. I don't have any idea if she has on her dance card doing this in the near future, but it really would be, I think, pretty incredible if Taylor Swift decided to take on, predatory or like anti-consumer ticket sales in the same way she sort of once took on predatory record labels, not through the courts. I'm just sort of saying, like, if she's looking for a new passion project, she could potentially make this that project. And I think that would be pretty exciting.
She'd be the man, a boss and a baller.
So we have a bunch of questions on the big news story in the past few days, the ProPublica report that Justice Alito took luxury fishing trips with hedge fund billionaire Paul Signer, who later had cases come before the court. Hannah asked about it in this way. In Vanderpump Rules, Lala mentions that she gives sexual favors for private jets, meaning that even a layperson in Hollywood understands that trips on a private jet are not free. You will pay one way or another. So the fact that Justice Alito thinks it's non-consequential to accept a free flight on a private jet, 100,000 plus one-way flight, and accept a luxurious fishing trip is completely absurd, and it proves just how out of touch Justice Alito is. How does Lala, a reality TV personality, understand this simple concept, yet a Yale law graduate and life-appointed justice on the highest court in the land does not?
So first of all, Lala has a very sophisticated understanding of our legal system. She basically spawned the catchphrase, "send it to Daryl," which was her demanding that her co-hosts send a cease and desist letter to her lawyer. So don't underestimate Lala. Second is, I think that this whole PJ thing is Justice
By which
Alito.
we mean private jets, not pajamas, for those who are not like all super steeped in our
that was a
in our
Vanderpump Rules
podcast.
reference. Lala refers to them as
they say
PJs.
PJ.
That's why I've been doing
I'm
it this whole time,
translating for
Kate.
our listeners who don't. I thought this was your coinage.
No. Okay, we'll come back to this later. But the whole PJ thing, I mean, look, Justice Alito obviously understands on some level that people are giving him things because he's a Supreme Court justice. But if the court's like public corruption, First Amendment, campaign finance, criminal fraud cases reveal anything, it's that they truly do not believe that buying access, right, and like gifting public officials with things is corrupt. Like they just think, yeah, you're buying access to me, and that's fine. That's just kind of how these things work. So on some level, I'm not sure he would deny that he is giving these people something in exchange, right? Like access to his precious time, his delightful skin, his charming personality. But he just thinks there's nothing wrong with that.
Slash, they have this just like kind of Olympian self-image, like they're gods, they believe that, and so they're like, we're not subject to suasion or influence in the same way maybe mere mortals are. And so even if there are concerns that might be well-founded in other contexts, like surely none of that applies to us. So to the extent they even like contemplate this, I imagine their sort of self-justification goes something like that. But yeah, they really seem, and the unbelievably defensive op-ed in the Wall Street Journal that Alito penned, the indignation that anyone could suggest impropriety. Also, he wrote this before, I presume he'd even seen the article. It's pretty wild, right? Like he got a list of questions from the reporters at ProPublica, and instead of answering the questions like a normal person, he spent the weekend writing this op-ed that, by the way, contains some unbelievably shoddy legal analysis that we, I think, pick apart on the episode of the podcast we recorded earlier today and will drop on Monday. But that was but he was like just completely irate that anyone would question the propriety of his, going on this fishing junket.
Alito should have sent those questions in that draft op-ed to Daryl as well. Send it to Daryl. That's what Lala says.
Speaking of ethical lapses, the ethical lapses of Supreme Court justice was on a lot of people's minds. And on Instagram, Kathy McPhee wanted to know, can SCOTUS judges be removed, or are we stuck with Clarence Thomas?
Well, I mean, in theory, they can be removed. Supreme Court justices, like other officers of the United States, are subject to impeachment. That is the constitutional mechanism for removing such an individual. That's a really difficult process. So you first need a majority vote in the House. And that is not a difficult process, right? It's actually, all that is required is a simple majority. Happened to Donald Trump twice, right? If the Democrats did retake the House, I don't think it's out of the question at all that they could have a successful impeachment vote. I mean, I'm not sure Thomas alone, if the ethics is the issue, would warrant it. I mean, the sort of like Alito reporting right now suggests that right now we know more about more kind of questionable and unreported, accepted largesse from billionaires on Thomas's part, but I'm not sure actually at the end of the day, like how the numbers are going to shake out. But in any event, imagine if it was Thomas or someone else. I don't think it's out of the question that a Democratic majority in the House could successfully not only initiate, but actually vote impeachment charges against Thomas. The problem is the Senate, which requires a 2/3 supermajority vote. So that's 67 senators to actually vote to convict and remove. So impeachment is the word that we use to kind of describe actually this two-part process colloquially, but the impeachment is actually what happens in the House, and then the trial and conviction is what happens in the Senate. So the first part of it, House, could easily be done with a simple majority in the House, and getting to 67 in the Senate such that you would actually remove a sitting justice from office is almost impossible to contemplate under current sort of political conditions, even if the Democrats hung on to the Senate, even if somehow, given the map seems unlikely, but even if somehow they increased by a couple of votes, their Senate majority, the possibility of actually getting to 67, unless we learn a lot of more information, I suppose anything is possible, seems really unlikely. And that is just, a feature, maybe a flaw of our constitutional system and the way we decide to retain judges for life, absent impeachment. Leah,
I think it's more, no, I was going to say, I think it's more likely that Republicans would get enough votes in the Senate to impeach the Chief Justice and Brett Kavanaugh and maybe Neil Gorsuch for being liberal squishes, than Democrats would get enough votes in the Senate to impeach, say, Thomas and Alito for corrupt, unethical behavior.
So this is a question. If they were able to sort of, if they decided they had the votes and they could impeach a Supreme Court justice, you think their top pick isn't one of the liberals, it's John Roberts.
Yes. They need to punish him for what he did in the healthcare case, right? This is like an animating view.
Yeah, I think it's true. I mean, he really is sort of public enemy number one. And, I'm not sure if his defection in the Voting Rights Act case that the court decided last week, Allen versus Milligan.
Just adding to the list of grievances.
And he only concurred and wouldn't have actually overturned Roe, even though he would have upheld the Mississippi 15-week abortion ban. In Dobbs, that too. I mean, there's
he's
practically
William Brennan.
Rescission.
He's practically William Brennan.
Okay, yeah, that's
Earl
impeachable
Warren.
right there. Yep, absolutely. High crimes, misdemeanors. That's what that means.
Yeah.
So this one might stump you both, but on Instagram, Hunkron asked, have Thomas or Alito ever made a legally, ethically, or morally sound ruling?
Great question. We pondered it a bit before we sat down to record. And I actually do have an Alito one, which is a 2008 Batson case, Snyder versus Louisiana. Batson is a case that basically says the 14th Amendment's guarantee of equal protection basically guarantees you a jury that has not been tainted by racial discrimination. So if, say, you're a Black defendant and the jury that it will actually decide your innocence or guilt is constituted in a way that is tainted by discrimination. If, say, the prosecutor has excluded all Black jurors or any Black jurors on an impermissible racial grounds, the Constitution prohibits that. So that's the rule articulated in a case called Batson. And Alito, in a 2008 case, actually finds a Batson violation in a trial where there clearly was one, but where Alito, in later iterations of Justice Alito, he's very new on the court at this point, concludes correctly that this rule requires the reversal of a conviction where the jury was tainted by discrimination. And Thomas and Scalia, who is then on the court, both dissent. And so Alito is on the opposite side from them. So that is the sole case that I could think of when the question was posed. Thomas, actually, I got some more. But do you have any Alito ones, Leah?
I mean, I was just going to list cases where they joined legally, ethically, morally sound opinions. I know. But after you took that, I was like, okay, well, I'll try to think of some recent ones. And all I could come up with were cases that they had joined majority opinions that other justices had written. So like Justice Sotomayor's opinion in Dubin from this term that said it's not actually aggravated federal identity fraud if you overbill, Medicare by like $100 and type in, the patient's name while doing so. Or Perez versus Sturgis Schools. That was a Gorsuch opinion that basically said said, parents of children with disabilities don't have to pursue, utterly nonsensical procedures in order to actually enforce their rights under federal law, the Individuals with Disabilities in Education Act. So those were the two I came up with.
And Thomas, I will say, actually, unlike Alito, has some pretty idiosyncratic views in kind of principled ways in certain areas of law. And I occasionally do think that he, not just like in a stopped clock way, like I actually think that he occasionally is substantively correct on issues. And so there's a case from like 93 or 94, maybe it's even, it was from the 90s, I actually can't remember the year now, called U.S. Term Limits versus Thornton, in which he is on the opposite side of my former boss, Justice Stevens, regarding whether states can decide to impose term limits on their members of Congress. So a bunch of states in the 90s were like, I don't know that people should be serving, like basically for life in Congress, and so passed through ballot measures term limits. And the Supreme Court actually struck that down and said, no, states can't decide for themselves. Like there are no term limits. If Congress wanted to do it, that would be different, but states individually cannot impose term limits. And Thomas totally disagreed, and I actually kind of agree more with Thomas's dissent.
So we've got questions for you on Trump because we did a bonus pod when Trump was indicted in Florida. We're expecting a few more in the coming months too. And this question is from Cameron. Is there a constitutional argument against a president being able to pardon themselves?
Maybe I'll just say briefly, self-pardon is pretty uncharted water, right? The Constitution doesn't actually say anything one way or another about a self-pardon. No one has ever tried it. No court has ever addressed the question. Nixon looked into the possibility of self-pardon, right, during the late days of Watergate. DOJ concluded, the Department of Justice concluded in a short opinion that was issued 4 days before Nixon resigned, that the president could not pardon himself. But that's like a very quick opinion that like calls itself sort of provisional in its thinking. And the Department of, the Office of Legal Counsel is an important body inside the Department of Justice, but doesn't bind what courts decide about the meaning of a provision of the Constitution, like the pardon power of the president. So the point, I guess the bottom line is we have no idea. And I presume that the fact that it's like an open legal question means that 100% certain Trump would try if in a position to do so again, not if he were reelected. And I don't know if a court would even decide it. I mean, there's this basic principle in the law that no one should be a judge in his or her own case. And that's kind of the basis of the conclusion in the OLC opinion, that it can't be that the Constitution allows for self-pardons. But also the pardon power doesn't have any explicit like textual limitations in it. So that's the argument on the other side. Well, it doesn't say you can't do it. So it really depends on, I think a lot of like background norms and principles. And also there's a real question about whether the court would ever decide the case at all, or basically say this is what we think of as a political question. Some questions courts just can't answer, and this might be one of them. And I'll just say one more thing, which is to my mind a really interesting question, is whether, if it looks like Biden is clearly like coasting to re-election, Trump tries to get Biden to pardon him. And I truly think that like I can well imagine Trump and people in his orbit trying to convince Biden that for the good of the country and sort of moving forward, we shouldn't start down a path that allows for, prison terms for former presidents. And I would hope that Biden would not be persuaded by such an argument, but I can well imagine him at least being open to it. And I actually think that's really dangerous. So, but that for sure he could do. Like there's no constitutional question. Biden could pardon Trump if he wanted to, if he was, either now based on past conduct or, in the future.
We should also note there are other limits to the pardon power. So in particular, the pardon power only covers offenses against the United States, meaning federal crimes. So, presidents can't pardon individuals for state crimes. And, as far as arguments against the authority to pardon yourself, Kate already mentioned the idea that, no one can be a judge in their own case. It's kind of inferred from, the Constitution and background principles. Another argument that people have made against presidents' self-pardon authority is the idea that the president has limited powers and that this would be, inferring or implying like a pretty big one. Related to this, Brian Colt, who's a professor at Michigan State, has argued that the very word pardon comes from the same Latin root as donate, and you can't donate something to yourself, and so that implies you can't pardon yourself. And then one other concept that like you might hear is the impeachment exception clause. So the impeachment exception clause is just the provision in the Constitution that says the trial of all crimes except in cases of impeachment shall be by jury. And some people have argued that that exception clause supports drawing basically exceptions to other constitutional provisions, in things related to impeachment, maybe also including the pardon power. But those are just some theories.
So we have some questions for you both about the future and the integrity of the whole court. This question was asked anonymously. Since the emergence of the 6-3 conservative court, there's an increasing feeling that the court will move to limit or strike down substantive due process rights. Originalists often argue that substantive due process has no limiting principle and takes issues out of the democratic process, citing Obergefell, Roe, etc. In your view, what standard should the court use to determine whether a right qualifies as a substantive due process right versus what should be left up to democratic choice? And what do you think that there is a truly strong possibility that the court will take up a challenge to Griswold, Lawrence, or Obergefell in the near future, even in the light of its diminishing credibility in the public eye?
So maybe just a quick word of explanation. So, substantive due process just refers to the category of rights that are not explicitly or specifically mentioned in the Constitution's text, but are constitutionally protected, formally under the due process clauses of the 5th or 14th Amendments. And the cases that Ashley was mentioning, Griswold, Lawrence, or Obergefell, are cases that recognize certain substantive due process rights. So Griswold said states couldn't criminalize contraception. Lawrence said they couldn't criminalize, consensual sexual intimacy between adults of the same sex. And Obergefell, rooted the right to marriage equality, partially in substantive due process as well. So, that's kind of the overview of this area of law. It does get mocked, I think, in some quarters, but I think that there is something to the idea, and this appears in the court's earlier cases in Pierce and Meyer as well, but the idea that the Constitution just protects rights that are foundational to free and equal democratic government, right? A world in which we are all equal citizens and can all participate fully in aspects of civic and social and political life. And so although that sounds, right, kind of conceptual and broad, I do think that that is a kind of important aspect in thinking about what makes a country a constitutional democracy or not, what rights are necessary to facilitate people's equal participation in society.
Yeah, and maybe I'll just add two things. One, people talk about substantive due process often, as Leah was just saying, sort of kind of mockingly or derisively. I, partly for that reason, because the term for a lot of people has a lot of baggage, I often think it's just better and cleaner to just think about liberty, right? The due process clauses are about life, liberty, and property, but the kinds of cases that we're talking about are really about the liberty protected by the Constitution. And so whether we're talking about what the sort of content of substantive due process rights are, or the content of the substantive liberty protected by the Constitution, the answer is the same, but I just find it more satisfying to think about liberty. And it's not that hard, I think, when you sort of think about, as Leah was saying, both what the kind of features or aspects of liberty that are kind of required to enable full and equal participation in the life of the country and the polity. And so things like control over your body, control over reproduction, control over sort of basic matters of intimacy and family formation, those are the kinds of rights that the court has protected under the guise of substantive due process. So, right, whether it's contraception or abortion, obviously before Dobbs, or educating your children in the earlier cases that Leah just mentioned, these are, elements of liberty that the Constitution, I think, properly understood, does protect and does prevent government from unduly infringing and undermining. And they're not, kind of wildly anomalous in international context either. Those are sort of the kind of core features of freedom and liberty that allow you to kind of flourish and really participate in economic and political and social life. And so those, I don't think, maybe it sounds amorphous. I actually don't think it really does. And whatever you think of the label substantive due process, I think the Constitution at least protects those things.
And who else said this is all about the word liberty? Julie Rickleman, in her argument to the Supreme Court, defending Roe versus Wade in Dobbs. Julie Rickleman.
I'm sorry, do you mean Judge?
Exactly. I was just about to correct myself. Judge Julie Rickleman, newly confirmed to the U.S. Court of Appeals for the First Circuit.
Connor and many people on our Friends of the Pod Discord, which you can subscribe to if you want more crooked media in your life, said, SCOTUS seems to be moving at warp speed to shred precedent. Law school teaches that there are rules, tests, and standards that guide the justices when they make decisions, and that these criteria can be applied effectively to fact patterns to draw a conclusion. Is that basic tenet of con law true anymore? Chevron has been all but explicitly abandoned, precedents are being overturned rapidly, and foundational principles of separation of church and state seem to be falling by the wayside. Is the constitutionality of law really based on whether it makes Sam Alito's tummy hurt?
You sound like the common law professor's group chats right now. Everyone is trying to figure this out. We do. I think there's a disconnect that is impossible to ignore between the way we talk about and teach constitutional law and the way this court is practicing constitutional law, and that is undeniable. And I think we are all grappling with sort of how both to convey that really important truth to our students, and also not, to completely surrender ourselves to cynicism, in part because they're not just making arguments to this Supreme Court, as lawless as it seems right now. Like our students and all of us, like there are lower federal courts, there are state courts, and I don't think that all of those participants in those courts have abandoned, any attachment to law and logic and precedent and those principles. And so I don't think that we can either, but it is an ongoing challenge.
Let's wrap up with the personal questions people had for you. Glazer asked, how do you balance the stresses and strains of the shit news cycles, SCOTUS sessions, award-winning podcasts, emergency episodes, law review articles with your daily regular lives? What tips do you have to maintain balance and sanity in these crazy times? You seem like superheroes to me.
You want to go first?
That's very sweet. I mean, we're definitely not superheroes, to be clear. And I forgot until the beginning of that question, there was a period after we won our Ambie Award where every time we opened the podcast, we described ourselves as hosts of an award-winning podcast. And then that kind of fell by the wayside. But thank you for reminding us.
I know. That's very kind.
So sweet. We all, I think, are kind of obsessed with exercise. That's really critical. I am more of a later in life runner, but a pretty obsessive runner. Now I've done lots of, different things to, sort of use as an outlet, but I run most days, and that is critical to my mental health. And the other thing I'll say is people don't always talk about this, but I have 3 kids and I have a lot of childcare. I think that's the only way to actually be as, on top of the things in the kind of legal world, especially at the end of the term, as they need to be. So I have a wonderful au pair who lives in our house and is extremely helpful with my 3 kids, and I could never do this otherwise. And I have in-laws who live in the Bronx. I live in Brooklyn, and are super helpful as well. So I do think that for people who have multiple kids and are super busy professionally, there's no way to do all those things except for with kind of a village of some sort around to support you. So those are my kind of secrets.
Definitely also exercise. Also, I have a dog I'm obsessed with, and she is a great stress relief. Also obsessed with reality television, which I use to decompress. And you have to find things to also treat yourself. So this summer is my Eras era. And so I am just going to Eras tour because that brings me joy.
And speaking of reality TV, the last question from Instagram is 100% for Leah. Who is your favorite drag queen of all time and why? And who is going to win RuPaul's Drag Race All-Stars Season 8?
Okay, so I will answer the first question in several parts because you can't make me pick just one. Obviously, Jinx Monsoon is incredible. Her performance on the All Stars, All Winners Snatch Games episode was truly unbelievable. The Judy Garland impersonation, just go watch it now immediately. Also always been a big fan of Trinity the Tuck. Think she's hilarious. Or Trinity the Body. I forget exactly which name they're going with. Sasha Velour, the Rose lip sync. I have on my phone several gifs of that because it brings me so much joy. I watch it in down moments. Also, obviously love Bianca Del Rio. I mentioned Bianca in my own biography on Strict Scrutiny's webpage. Obviously fell in love with Sasha Colby from the last season. Also love Shea Coulee. This Is How We Do It in Chicago, the little puppet impersonation of Shay is one of my all-time favorites. This is going long, but I still have more to add. Love Simone. Also love Rosé, Katya, Monet Exchange, Detox. Love Detox. Has a lawyer song, Litigious. Go listen to it. Miss Peppermint. Also love the Anitra Marsha lip sync, which we talked about at our live show at Howard. Is iconic. Also love Alyssa Edwards, and the Alyssa Edwards Tatiana lip sync to Drive is another personal favorite. And I'll stop myself there. I could go on because we were informed that this video could only be a certain number of minutes. As to who I think is going to win RuPaul's Drag Race All-Stars 8, I think RuPaul loves Jimbo, and I think Jimbo is getting a very favorable edit. So I think that is a possibility. That's what I would say.
I think that definitely took us over our minute allotment, but it's really worth it. I'm really glad we did. All right, I think that wraps it up for Strict Scrutiny's very first office hours to answer your burning questions. But I think we will do another one of these soon, possibly with beverages. We will see. But you can either way keep sending us your questions, and the best way to do that is to email us. Email address is strictscrutiny@crooked.com. Again, strictscrutiny@crooked.com. Thanks so much for joining us.
Bye.